O'clock, and appears we have quorum, so I think we're good to go to get started. Mr. Atwood, he may have gotten stuck in traffic. If so, we'll just get him caught up when he gets here. In that case, let me first off start off by welcoming our two new members. We got Nelson Pratt and Sandra Tuck. They come to us with a wealth of experience, so we look forward to putting them to work. So we won't hesitate, and thank you guys. We appreciate your service. And all right, so we don't have a chair today. I think Rex was our chair, and so he's rolled off. He's expired, and we'll probably at our next meeting we'll do our election of officers then. So I'll try to steer us through the meeting. All right. We'll do everything since we have a quorum in presence. We'll do all of that by voice vote, unless otherwise required. All right, so this meeting is called to order. It is 9 o'clock. Let me go ahead and read the the meeting notice into the record. Notice of the November 15th, 2022 meeting of the Real Estate Appraiser Commission, including date, time, and location, has been noticed to the Real Estate Appraiser Commission website since November 18th, 2021. Additionally, this month's agenda has been posted on the website since November 4th, 2022. And there's our man. All right. You're right on time. You're all right. Oh, it was beast. Wherever you like. Yeah. We don't have a chair. Rex, I was just catching the commission up and letting them know that Rex has rolled off the board. That seat in the center must be terrifying. It's all right. We're gonna make it work. All right. Well, we just called meeting to order, Jim. So you're right on time. You should have the agenda and all its contents there. You had a chance to review that over the last few days, but it should also be on your iPad. Is there anything any adjustments or edits you'd like to make to the agenda as it is? All right. We'll need a motion to accept the agenda as written. Do we have a motion?
Accept.
All right. Thank you, Ms. Alexander.
Second.
Got a second from Mr. Bennett. All in favor, please say aye.
Aye.
Any opposed? All right. Hearing none, that's been accepted. All right. Off to the July minutes. Are there any edits or any comments in regards to the July minutes? There's the occasional typo, so you don't have to be gentle if you see anything. All right. Hearing none, then we'll just take a motion to accept the minutes as written. Do we have such a motion?
So moved.
All right.
Second.
Got a second. I got a motion from Mr. Mansfield and a second from Miss Alexander. All in favor, please say aye.
Aye. Aye.
Any opposed? All right. Hearing none, that's been accepted. We'll get that on the website and posted. All right. And looks like we're ready for experience interviews. We had a few updates come in. So let me just read what we have into the record. And then if you want to fill in the gaps, if I'm missing somebody, we can do that. All right. So Mr. Atwood, we had Laura King, Christy Frame, Jacob Miller, and Dalton Furr. And those were all recommended for certified residential. Is that correct? All right. Did you have anything for Johnson Winkleman yet or no? Oh. Okay. Very well then. So then I'll cross him off the list. And Rex, he already, on his way out, he took care of Dwayne Dillard, and that recommendation was a yes for certified residential. Carrie Haston, she is also rolling off the board. So we've got a lot of vacancies to fill. And so this will be a relatively new board. We've got a couple new members, but then a couple more coming. So we've got, from what I understand, there may be at least one or two in the pipeline. So we're going to... Right. But she approved Brian Berger. And then we have Mr. Mansfield doing some heavy lifting there with Tyler Camera, Nada Payne, Lewis Cosby, and Linda Collier. And those were your recommendations for certified general, licensed, certified general. And then we don't have anything on Sharon Arbogast yet, right?
No, I did meet with her and we'll recommend approval.
Okay, very well. All right, so we'll update that to a yes for approval on those. All right, with that being said, and those being the recommendations, do we have a motion to accept those recommendations?
So moved.
Second.
Got a motion from Mr. Atwood, a second from Ms. Alexander. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none, we'll take care of that. Thank you for digging into those. We appreciate that. All right, application reviews. We just got two before you. Those are some pretty, I mean, we give you everything because I want to make sure you have everything we have in case there's something that you spot out that maybe we missed in our summary. But let me just start with Ellis. All right, and that would be 4A, and then the tester app is 4B. So we're at 4A. Per the ASC report, Mr. Ellis is licensed in North Carolina, which was obtained in 2015. He has a voluntary surrender date of a Tennessee license here of 5/16/2016. And prior to that date as well, he was only licensed in Tennessee. And I wrote a quick summary when I sent out these documents, but in essence, a license can't be permanently voluntarily surrendered. And so he's back. It's basically a re-review. We're saying, is he in good standing? And even though he doesn't have a license here, we know that it can be permitted due to an active license in North Carolina. That's typically the process. If they have an active license somewhere else, we recognize reciprocity. Even though technically he could be considered in good standing, we still want to bring it before you, do our due diligence, just because there are a couple statutes that allow you the right to deny if you so chose to do that. So that's what we have with Mr. Ellis before you today. And again, I trust you've been able to look through his documents, and we'll stand ready to answer any questions.
He's not with us, is he? On the phone?
I don't believe so. We can check. Mr. Ellis, are you on the phone? We only had two phone numbers. I didn't recognize those. No?
No, this is PK Jain. Yeah, I'm on the phone for the education report.
Oh, great. All right. Thank you, Dr. Jain. All right. No, we do not. Let me also check. Do we have Tester on the phone? Okay. Thank you.
I have several questions. The violations that led to his surrender, get the right correct, serious. And my questions are, has he done anything in the last 5 or 6 years to upgrade his competency level to over?
I don't know of anything. Also, if you can just, if everyone can make sure when we're talking to keep their mics on. They're not, for some reason, sometimes the light isn't staying on. So if you can just make sure to hit the speak sometimes so we can make sure everything's on the record. We don't have any additional information other than what's been provided to you in your packets.
Do we have the authority? I read through this, and it says that we can't add any more requirements to that complaint. But do we have authority to request, as a part of his application, courses that he's taken within the last 5 or 6 years so that we can know what kind of education that he's engaged himself in? Or do we have the right to request any current appraisals that we can review so we can know that he's not still making these same mistakes?
Well, I think if you would like to request that information, you can. So the reason it's being brought to you today is for the commission to make a determination of whether you want to grant the application for a license, for a reciprocal licensure today. So if that is something that the commission would like to see prior to potential licensure, that is something that we could request, but that is not something that he would have to provide to the commission. So that is something, of course, he could say no to. And the commission would not, it's not something you're necessarily entitled to.
It's a little bit, and what Anna, and of course, correct me, Anna, if I get out of my lane. But in essence, this isn't, he's already taken care of the disciplinary action process. He's already dispatched that. And so we can't enter back into that since that was closed. So it's just an application review, and the application review is what's before us. So if we do decide, the issue too is that the statute allows for that, but then does the commission want to start litigating that, or sort of a step away from the process, which right now is to accept active licensure reciprocity with other states? So that's, if we do that with this one, then we're opening that up if we exercise that. So we're saying you can, but it doesn't mean you necessarily have to, that's up to you, obviously, but it's delicate, but we want to make sure that we bring, if there's any authority whatsoever that can be exercised, that we just want to make sure that the commission is aware of it, but it doesn't necessarily mean that they have to exercise their discretion in that regard.
If Mr. Ellis is in good standing in the state of North Carolina, it's my understanding he would have had to taken USPAP and any other requirements to stay in good standing within that state, correct?
That's correct. That's a good point. A good follow-up point too is that this would be an aggravating factor for former discipline should he have another complaint here. So that's one of the rails, the guards that is put up as well. And so, whatever terms he had before, that can be elevated on his next complaint. So it's not that there's no teeth, because obviously prior history and record is a factor when it comes to, for lack of a better term, sentencing. But, when it comes to deciding disciplinary action.
So can you just kind of speak on, so if he was when voluntary surrender occurs, how long, there's no time frame with that, correct?
Let me look at their order. So here in Tennessee, a voluntary surrender means your license no longer exists. So there's not a time frame. But that is not necessarily the standard for every single state. But let me look in this particular order to see if we have further clarification. So it states in the stipulated disposition, respondent shall voluntarily surrender respondent's certified residential appraiser license number 457 immediately upon this final order becoming effective. So, excuse me. So to me, that has like an infinite date, meaning that their license ceases to exist. So license number 457 no longer exists. So if the respondent were to apply for licensure in the future, that they would need a new license.
So what is this individual applying for? A new license? Based upon reciprocal relationship with North Carolina, not because of anything he has or has not done here.
Yes, sir. That's correct.
Mm-hmm. Proof. License in another.
In South Carolina, by the looks of things.
Have no proof other than other licenses in other states that he has elevated his competency level to deal with the issues that caused him to surrender his license to begin with.
Other than no other disciplinary actions since then that have been reported to the National Registry.
Do our disciplinary actions show up with the National Registry for this specific gentleman from this date?
So,
because when you look at the printout that you have, says, okay, it does say voluntary surrender. Apologize.
So the reason that the reason it came before you is because the definition of good standing goes back for 5 years. But under the rule for reciprocal agreement, it states that if a licensee or certificate holder's out-of-state real estate appraiser license or certificate has been revoked, suspended, denied renewal, or restricted, then the commission may revoke, suspend, refuse to renew, or restrict the licensee's or certificate holder's state of Tennessee real estate appraiser license or certificate. And so to me, that I read that as being outside of the good standing rule, meaning that if you made the determination that the individual, that is something that you decided you did not want to grant a license for reciprocity, you would not have to. But technically, if Mr. Ellis were to apply not through reciprocity and through the typical process, he would be in good standing and would not have to come through this process because it would be beyond the 5 years.
But I think the issue with that is if he did take that route, he would have to take all the classes again and go through the experience. And so this almost seems like a loophole in the process, because he voluntarily had to surrender his license, but now he's just getting another one because of reciprocity. And I think that's where our hesitation lies.
I just wanted to explain exactly what the reasoning was, because I do know that the 5 years may be there may be some questions.
Yeah, and certainly because there's not standardization across the board. I used to have an insurance adjuster's license many moons ago, and a lot of folks, the Kentucky was the hard exam, but yet Kentucky was reciprocal with everybody. But you could go to Florida and live as like a breeze, that one was, and then you could get the same reciprocity with everyone. So a lot of folks would call that a loophole, and a lot of the administration at the time, not here, but in a former life in the private sector, they realized that it was just easier to send everyone to Florida and then get reciprocity that way. But until there's standardization, there are pockets like that show up in licensure, certainly. Other comments or notations, or all great comments across the board, as I would expect from this commission. You guys always do a really good job sort of fleshing all that out, and the idea is public protection, and so there's some of those tools may appear to be limited, but at the same time too, there's we do have a fail safe in the sense that they have to exercise according to their competency, and should they get a complaint, that would certainly factor into the way we treat and handle that one going forward.
This is just for us to have a conversation about, or do we have to make the decision on this license, or is that decision to be made by you all?
No, so this would be a decision that you would make whether this individual be permitted to have a license in Tennessee.
Based on Rule 125.01.092D or E, Anna gave that citation, and shared that with you previously. But so you can, but then if you exercise that discretion, then we would have to do that. There could be similar situations where we're breaking with process again, and then we're having to litigate that outside of the disciplinary action process, outside of the legal report, which is our main vein for doing that. And so you have to decide if that's what you want to do. But
I do notice that number 3 says that the Department of Commerce and Insurance shall institute no further action against respondent for the acts or omissions alleged in this contested case. I mean, if we hired him to
Are you reading that from the agreed citation or the agreed orders? Probably is where it's coming from. Yes, ma'am.
Would you explain a little more what you mean by down the road other cases might be complicated? Would you explain what that means a little bit more?
Well, the process as it currently stands is if they have an active license elsewhere, then we accept them. If we start looking into disciplinary action here or otherwise to make those determinations, and then we're going to have to start setting criteria. Potentially, that criteria, if it turns into policy, will have to be rule, and that's what I mean. Well, yes, sir. Yes, sir.
I have no comfort level in approving this until I understand that the individual has taken necessary steps. And so we can say that his being licensed in other states and no current complaints, we might can say that is sufficient, but for me it's not. So if we're waiting on a motion, I'm going to make a motion that we deny his application.
Second.
All in favor, please say aye.
Aye.
Discussion.
Yeah, and then any discussion then.
Is there any way that we could kick this down the road to the next meeting and maybe request, a list of what he's done since that time, if he wants to submit anything to us, a letter or anything like that, and so we could take that into consideration for review?
And can I add to that? One thing that I would kind of caution or question is if someone does have good standing and that's the policy, at what point where do you draw the line on the criteria that good standing is permissible or not permissible from that other state? That's just one question I have.
Well, let me clarify. So, good standing is something that is universal across the different jurisdictions, but there is this provision in the rule, and so I don't want you to get confused that you can't do you can do this. It is the two are not Jesus, the words are, you can do both. They can exist at the same time. So I don't think that you're going against good standing and also adhering to the same thing, because the rule is there for a reason, and the definition for good standing is also there for a reason. I don't think that the two would exist to be in direct controversy. So otherwise it would not be there. There would be some kind of provision that would say but for. So we have certain circumstances that fall into the category. We don't see this very often, and so that is something to definitely keep in mind. So if the commission would like to have additional information to request of Mr. Ellis to look at the next meeting, that's something we can certainly do. Obviously, it probably might be in his best interest to submit that information, but again, that's up to him if he wants to do so. Again, that is your decision whether you would like that to happen. But personally, I believe that you do have the authority to do either way. So I think you're okay one way or another.
Based upon the previous surrender of his license, does he have good standing in Tennessee?
Would he have good standing?
Does he currently have good standing in the state of Tennessee?
Yes.
How can that be when
he has no standing?
He doesn't have
He's not a licensed
he
appraiser.
doesn't have a license in Tennessee.
He has no standing.
So but if he were, like I was explaining to Commissioner Mansfield, if he were to go through the whole process, not through reciprocity, and do everything from the beginning and successfully complete that, he would be fine. But that is not what we're doing. We're skipping all of that and going through reciprocity. And because we're going through reciprocity, there is an extra rule that is there that gives you an extra amount of authority when you have a certain level of discipline that gives the commission another level of discretion. But to deny a license if you have revocation, suspension, voluntary surrender, etc., etc. Does that answer your question?
Request, is it just for this application or is it for all future applications?
It's just for Mr. Ellis.
But could he apply again, make an application in a year? Is this a one and done deal?
Apply again.
Makes sense to request that information to see if there's anything that's been done in the course of education or, since that point in time. He may not be required to provide it, but it could be that if he's done those certain steps, he may want to provide that information.
That's completely up to you. If that is something that you would like to see, that is not something that is required in the rule. So that would be something additional that you're asking for. So that is all that I'm saying is he would not be required to provide it.
Since we do have a motion on the floor, the individual making the motion, Mr. Atwood, if you wanted to amend your motion to include that, then you'd be able to that, but you don't have to, obviously.
I don't mind amending the motion. So I'll amend the motion to say that we would like to have some form of support that Mr. Ellis has increased his competency level since the date of this consent order, either by way of indicating to us what courses he has taken in the last 5 or 6 years and passed, and by way of submitting 2 or 3 samples of his work that can be reviewed by a competent reviewer and decision.
Okay, so, and you correct me if I'm wrong, I just want to restate that motion for the record. Your motion as amended would be additional support from Mr. Ellis to demonstrate increased competency since his original voluntary surrender, and that could come by way of courses, samples of his work, and any additional supports that he may deem appropriate for the board to hear.
Said that much better than I did. Thank you.
Yes. So that's the motion. Do we have a second then?
Can I make a comment on that?
Yes, sir.
Before we
Yes,
go?
please.
Could we potentially, instead of just getting him to send in a report or two, get a list of 10 or 15 reports that we could then pick a couple from? I feel like that would probably be a little bit of a better representative sample.
So when you say a list, like you want him to provide 10 or 15 reports?
A list, and then we can pick 2 as we want to. So he sends in his last 15. These are the last 15 reports that I completed. We tell him we want these 2.
That's that's a lot to send through the interwebs. So I'm just asking, like, how you like that to be done.
Mr. Ellis, please
No.
send us a list of your
No,
last
I'm
15
just
reports.
I'm just asking,
Yeah.
I'm just thinking size wise, through.
He's not sending 15 reports in. He's sending a listing of the
Okay.
last 15.
We can do a
Okay.
log. That's not a problem. Yeah.
Oh,
So,
okay.
and I'll
Apologize.
just when we reach out
Okay.
to him, I'll just give him some of the recommendations of what would satisfy that investigative sort of curiosity or probe that we're asking for. So that follow up that we're looking for. So yeah, I'll give him the rundown. So a log for which a random selection can be made, courses as well, or anything else he wants for consideration from the board as well, because there might be something that we haven't thought of that would shed some light on that. So we'll just re-review at our next meeting, and then but we'll need to close out that motion for us to do that. So is there any other comments in regards to that?
Second.
We got a second then for Mr. Bennett. All in favor, please say aye.
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 Any opposed? All right, hearing none. I think we're ready for our next one then. The next one is Miss Tester. She had her license suspended in North Carolina in 2009. And so she's looking for a temporary license here now. She does have an active license currently, but due to the Reg 1255-06027 states, if a temporary practice permit holder's out-of-state license has been revoked, suspended, denied or restricted, then the commission may revoke, suspend, refuse to renew, or restrict a permit holder's temporary practice permit. So that's why that's before you right now. She's seeking a temporary practice permit where she has an active license, but because it was suspended and she would fall underneath that rule, so you may, it doesn't say shall, but you may consider that and exercise your discretion in that regard to her application. So I'll let you get a chance to sort of collect your thoughts or present any notes that you may have in regards.
Is it my understanding that this applicant trainee license was rendered a trainee license? It says her license number is T something. The undersigned respondent to Neil, holding certification A287, and respondent tester holding registration number T3600. Is that a trainee license?
It is. It says on her history.
Okay.
And then there's some gaps in there as well.
But she was working under the supervision of another appraiser and got caught up in something here, it looks to me like.
That's what it appears to me as well. And if you notice too, on her ASC, there's no history listed there.
Okay. And then
That's what I was going to. There's been nothing since her certified residential license in 2009.
And she's a certified general now.
Yes.
So she's already been moving along the chain since then.
so no problem with it.
I'll go ahead and make a motion that we approve.
Second.
I got a motion from Mr. Mansfield to approve that one. Second from Miss Alexander. All in favor, please say aye.
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 Any opposed? All right, hearing none, I think we're ready for our next item. Thank you. I always appreciate the discussion. Education report. What we're going to do is we're going to go over the education report, enter that into the record, and then we have a few of our education providers that would like to address the board. And so we'll go in sequence of the order for which they signed in, and I'll announce them. And we have Dr. Jane on the phone as well. So I think we have got everything we need. All right, so got the education report there before you. There was, I'll let you take a look at 2 pages. Primarily.
And I can provide some background if you like.
Yes, sir, please.
On the report. So there were 22 courses that were filed for approval, and the education committee has reviewed. Bill Best and myself, we have reviewed the courses. 16 courses are recommended for approval, and the 6 courses have not filed course contents, and we have provided example in the past, like providing the text or slides or video links or any other form of course contents that will ensure that the courses offer high quality lessons in appraisal, and they're not in something else like how to play golf or something like that, right? So the material enable us to also demonstrate from the side of providers that they're actually well prepared to deliver the lesson, and then the course takers, appraiser will learn something from them. So that's the reason we want to ensure high quality. So please do provide, all the vendors do provide some form of course, complete course contents, whichever is easy for you. Thank you.
Thank you, Dr. Jane. Does anyone have any questions for Dr. Jane on the commission as it pertains to these courses that you have in front of you right now? I will say, okay, you do have all the, you do have the recommendation because on my iPad, so it would be on yours as well. Anyone, any comments?
I've got a question, Dr. Jane. Course 2626, it looks like this is a 4-hour, maybe seminar, maybe not an in-class. with a book, continuing education. Can you provide a little bit of clarity exactly? And I know you said slides and material, but for these seminars, what exactly would be best to present? Because if this is just a speaker, maybe they don't have slides. What exactly would be best to provide to you for recommendation for approval?
Yeah, I think we are applying a consistent standard to ensure high quality, and I understand what you're describing and sometimes be a little problematic. If they have a video recording, if they recorded a past, for example, a speech that they have given in the past, and if it's a first-time speaker, maybe they can write something about their notes from which they're going to speak, just to ensure that the appraisers do learn something, because otherwise it's hard for the commission committee to assess what we are approving. Does that answer your question?
Yeah, it does. Thank you.
Thank you.
Any other commissioners have questions, comments?
Question. If something is showing approved on here and it's already happened, do they get retroactive approval for it?
That is correct. Yes, ma'am.
Okay.
That's another way. So sometimes conferences are purely speaking and interaction or panel. So then it can be filed ex post, and we will approve it. So that way, those who have attended the conference, they get credit for it. So I just want to make that clear as well. That we do need some evidence that it was a meaningful education, but it can occur after the conference as well. So please file immediately after that.
Or comments? All right. In that case, let's move to. We'll have to take some action on this report. Dr. Jane would be the motion to approve the report. Do we have a second?
Second.
We got a second from Miss Alexander. All in favor, please say aye.
Aye.
Any opposed? All right, hearing none. That report has been approved. Now we can turn to our education providers that would like to address the commission and provide some comments. Now we have 3 right now that have signed in. Let me go ahead and call our first one to the podium. We have Mr. Humphreys. And if you could just identify yourself and then jump from there.
Sure, thank you. My name is Hal Humphreys. I am with Appraiser e-learning, and we have had some serious struggles with getting courses approved in Tennessee. For instance, the Appraisal Summit was submitted for approval June 2, 2022. The Appraisal Summit is hosted by the National Association of Appraisers and Appraiser e-learning. Speakers include Jim Park, Executive Director of the Appraisal Subcommittee, James Hazlett, VA Chief Appraiser, Scott Reuter, Director of Valuation for Freddie Mac, Lyle Radke, Director of Fannie Mae Collateral Policy, Scott DiBiasio, Manager of State and Industry Affairs for the Appraisal Institute. If these people present at a conference, I'm going to assume everybody in the room who is a real estate appraiser understands that that would be beneficial to appraisers to hear from these people. Fannie Mae, Freddie Mac, the Appraisal Foundation, the Appraisal Subcommittee routinely do not submit their slides until the day they're going to present. The Appraisal Summit had 15 appraisers from the state of Tennessee attend. They are still, to this day, waiting for approval. It was submitted for approval June 2nd. We're working on almost 6 months to get an event that happened in October approved. I guess my question is, what, Dr. Jane, can we do to speed up this process? You're hurting Tennessee small business. which is my problem, but you're also hurting Tennessee appraisers by not allowing them to have access to current information from appraisal industry thought leaders and approving this stuff in a timely fashion. That's all I have to say.
Thank you. So is there a specific course number? I think we approve in every meeting that they are submitted along with the contents as expeditiously as we can. The commission does have to meet with all the commissioners in order to approve, and the meetings are, I think, every 3 months. So there should not be more than 3 months delay if some form of materials are filed for approval.
Okay, Dr. Jane, my question is, the appraisal summit is being approved today. It is November 15th. It was submitted for approval on June the 2nd. That's 5.5 months. That's more than 3 months. Tell me what we can do to get you to expedite this process so we can get these things approved. Last year at the ACTS conference, we had a former chairman of this very board attend the conference and not be able to get credit until 5.5 months after it was submitted. This is 38 other states approved the summit within a month or two of submitting for approval on June 2nd. Our home state of Tennessee is approving this course today. So help me understand what we can do to get our courses approved in a timely fashion, to help us out as a small business here in the state of Tennessee, but also to help your appraisers get access to current education.
I'm totally with you. We should approve as expeditiously as we can. I don't know if we need a special meeting for that. It's a broader question, I think, for the entire commission to maybe email approvals, or I don't know how else this would be done to bring it in front of the commission.
Once the courses are approved by the education committee, in this case, Dr. Jane, as soon as you're ready, once it's approved, we can apply that and then formalize that in the meeting. So we don't necessarily have to wait on the meetings or call like a special session or anything like that. I understand why there might be some confusion in that regard, because typically action items outside of committee or work, especially as when the committee itself is really the work of one or two individuals, and is typically that's sort of a variant in the process as you see with other actionable items. So in this case, we can send out, and one thing I talked to Will about as well, we can just, you get those courses in your folder as we get them, but we could assist by giving basically an update once a month at least, and then just approve those at those times, and then bring the report to the committee at their meeting. If we were to do that at least once a month, I think that would solve the problem. What do you think?
I think that would help the problem. I do think there seems to be a hiccup in the process when you've got a conference or a 4-hour presentation from a credentialed, well-respected person in the industry, and we're looking for some, I don't know what. We're providing slide decks, we're providing speakers, we're providing timed outlines. What else can we do to get these things approved?
Mr. Humphreys?
Yes.
When you submit the speakers, do you submit their credentials in that packet?
Absolutely.
Okay, so Dr. Jane's not an appraiser, and those names that you just mentioned, we all recognize. He may not, but you're putting their credentials as appraisers in your packet, so he can know the credentials of your instructors and your speakers.
We're putting their credentials in the packet, including the fact that many of them are with the Appraisal Foundation, Fannie Mae, Freddie Mac, VA, FHA.
And is there an itinerary of what they're speaking, or you don't know what they're going to be speaking about?
There's an outline of what the topic they're supposed to speak about is, but again, when you're dealing with the appraisal subcommittee,
I understand.
it's got to go through legal before they get up and say anything. So we don't know exactly the words that are going to come out of their mouth until they get up on stage.
But an outline.
Right.
Okay. Do we know on average, so we've got this full list today, do we know on average how long ago the items we're approving today were submitted?
That can vary on provider. We'll have some, just like any personality. Certainly not to represent anyone here in this room because I don't know, but I'm just saying that can vary. We could have some folks right at the last minute, others like in months in advance, and obviously Mr. Humphreys gave us an example of one such a course.
I know, but we got to have on average this takes,
I can say
3 months, 5 months, 7 months.
5.5 months is the average approval we've seen for conferences, and that is just not tenable.
We have multiple conferences on here, and some of them we're still asking for information, like the 2022 International Conference, which is a 14-hour. I assume that's just a...
I think it's maybe a question for Dr. Jane. What sort of time frame, what sort of lead time would he be looking for, just so it's out there and it's crystal clear and all the education providers understand? If they get him something 3 months in advance with the required information, what sort of lead time with the monthly review would he be looking for?
Yeah, I think 1 month is a fair time for the committee to meet, but I think maybe there is a process needs to. I don't directly receive any materials from the vendors, so it comes through the commission staff, and there is some mechanism through which they share it with me. But they could probably alert if there are materials which have been filed, and send some alerts expeditiously or reminders. So that may help with the process. I was also not aware that the entire commission does not have to. I think we have to meet and approve as the entire commission. It could be an email vote. That we typically make sure that right before the meeting that everything which has been filed has been reviewed. So that's the process that I've been following, is that before the full commission meeting, everything which has been filed up until the last 5 days even, or 2 days, I am very happy to sit with the committee and review it with Bill Best essentially, right? So that's, I am not for delay at all. I think the more expeditiously the materials can be approved, the better quality of education the appraisers are getting. So the faster we can do it, I'm all for it, process improvements. Thank you.
So it does appear there's two issues of consideration. One is the length of time it takes to approve, which, if we're getting those the at least monthly updates where we're getting those reviewed and turned back in, then we can respond. So then there's the other issue of content required. At the bare minimum, we have the outline and the credentials of the instructor themselves. That's at the bare minimum. And so then it was the other items, as you saw on your iPad, that were being requested in addition to as well. Do you have any other further comments?
I do have. I've got a. So I know for a fact in the past, and I've spoken to several educators around the state, that in the past you could submit a timed outline, speaker credentials, and maybe a slide deck, and get that approved post haste. So if that's what we need to provide, then that's fine. We can do that. We're doing that. The question is, Dr. Jane, what rubric are you working off of to say, I need this, 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 or this? You haven't defined what materials are.
Yeah, the issue why we have been looking at the course content is because there were complaints brought to the commission that there was appraisers coming up for interview and they received no education. In the interview, it was clear that they were not receiving the outlined material. So that's why we started looking at what the course content looks like. Are the providers even prepared? I don't think it should be a problem with very reputed providers like yourself, but we want to apply a consistent standard where anybody cannot just show up that I do have a course and I filed an outline and it should be approved with no quality control essentially. So I think there are two different matters like you're saying. I think it's to the benefit of the best providers to provide and file any form of material. We want to provide flexibility. There's no one rule. Slide decks are totally fine, or whatever you can in terms of showing that the educators were prepared. Maybe they have a video link, or there could be just a text, or they may be using a textbook, so you can tell us that here's a textbook and I can look it up on Amazon, for example, that yeah, this textbook exists. So we are just essentially looking for what materials are being used
so
for providing education. Yeah.
Tell me if I'm hearing you correctly. The complaint is we have people sitting for interviews who didn't get the education they needed.
Right.
Okay. That would be qualifying education. Am I wrong about that?
Yeah, that was qualifying, but the same also extends to continuing. If those type of providers are claiming continuing education, it would be the same issue as well.
Are continuing education, are people sitting for interviews based on continuing education?
No, they're not, but the standard, the same problem applies to both types of education.
Okay.
Unless there's any more comments from the commission, Mr. Humphreys, I'd like to get to the other speakers.
Thank you, guys.
But I do appreciate your comments. One thing that we could do too, as far as the expeditious part, the content part, obviously, I would have no say in that regard. But to the expeditious part, what we've done, like a lot with our application reviews in other disciplines, other industries, is that we'll just have two folks sign off on it. And then you grant that authority to administration to take care of that with two signatures. And so Dr. Jain would be the first signature because he's the education committee, one other member from the board, and that's done. And then you're just granting that authority to us, and that is your board approval. That's your board review. And a lot of other disciplines have done that. And we could go that route if you're willing to go that route.
I think it's a great idea. Things, and I was also going to offer. Dr. Jane's not an appraiser, so like Commissioner Atwood said, he might not understand or know. Hey, this has been approved in the past. There's been a precedent for this conference, but he doesn't understand the speakers that are there, and so I'd make myself available if he wants to discuss or have questions or whatever's needed to help
right, and we were just talking that afterwards it would just come back to you maybe at a meeting afterwards retroactively, and you would be like, these are the courses that came through with Dr. Jain and Commissioner Mansfield, and this is what you looked at. And so I think that might also help move processes forward so we don't have to wait for quarterly meetings.
I think it's helpful too, because then it'll provide it'll add kind of build out that education committee too, so he's not solo, and then you can just now keep in mind you can't go direct to one another because then that's a meeting, but you can bring your comments, your questions on the application that you see to me, for which I can forward to Dr. Jain and then be your intermediary for that conversation, or through Will as well. I'll let you cogitate on that for a second.
And to Dr. Jain's point, I think the problem we were having in the past wasn't the fact that people were we didn't have enough information on the front end for them to be approved as a course provider. Their information was thorough. It was what they were actually teaching during the class wasn't what they said they were teaching. So I think there's maybe a slight disconnect there, and we've discussed in the past about having potentially a proctor to go into some classes to make sure, and I don't think that made it very far, but
yeah, I know, that's a good point, but what we are doing is another way, and it's a mitigating factor to the same problem. Because appraisers are smart people, right? So if the materials are there, they can self-learn to some extent. So that was a short of visiting the classes for auditing or to exactly see if what's being taught is what's being submitted. what's being submitted is of high quality. I think that works to some extent. Thank you.
If it pleases the board, then what we'll do is we'll get our comments from our other two providers. They'll give you some more time to sort of let marinate with the initiative I was just discussing to you and outlined to you there. And then if the board would like to take some action on that regard, we can at the end of those comments. All right, so I'll go ahead and invite our next speaker up to the podium. Is it Mr. Van Dever? Is that correct?
My name is Seth Rowling. I'm the incoming president for the Appraisal Institute Tennessee chapter this year. We have been facing a lot of the same challenges that Mr. Humphreys spoke of with getting particularly CE approved. And so my hope is just to bring some awareness to the board of what we've been facing and just create some discussion within the board about those challenges. Two main things were the two things that we've already been talking about, and that's with regard to CE, the main hurdle we've been facing is the need for course materials, student handbook, and many of the continuing education seminars that we are offering do not have that. It might be a homegrown course that an appraiser writes on a pertinent topic that the profession's facing, and it's even without a handbook, it's very valuable information that appraisers can take back to their office, immediately implement into their appraisals, create a better product, and increase the public trust. So I think we just need to make sure we're recognizing there's a difference in QE and CE, and those requirements may need to be a little bit different. And then the other issue is the timing of getting them approved. Having meeting 4 times a year for the approval doesn't seem to be working. So it's like we've already discussed. If there's a way we can expedite that, once a month or whatever y'all see fit. But 4 times a year does not seem like enough at this time, and it's creating some issues with appraisers being able to get their license renewed. If they've taken a course, their renewal comes up before it gets approved, then they have some issues getting their hours. And so that's really all I had. I don't want to be too repetitive from what Mr. Humphrey said, but it's the same issues. So thank you.
All right, Taylor, is that correct?
Yes, sir.
Okay.
My name's Taylor Vandiver. I'm just this process. I just wanted to share a few experiences with you, but this process or lack thereof has caused me some great personal issue or professional issue. I'm an MAI appraiser. It is very difficult to get continuing education in the appraisal profession. I've got license to appraise property. I'm a licensed real estate agent and I'm a licensed attorney. And by far, the most difficult continuing education to get is appraisal by a long shot. I can spend $200 and get my entire real estate continuing education from my computer in a couple of days. I can spend probably $300 and get my entire legal continuing education at my computer from my house in a couple of days. The appraisal profession, way harder. You have to go to a lot of in-person classes. There's not even a lot of classes that are relevant to my career as an MAI. Most of the classes that are being offered are residential and not really relevant to what I do. I attended the Appraisal Institute conference in Las Vegas this year, seeking in-person continuing education. It's a Appraisal Institute, in my opinion, and probably the opinion of most of you guys here, is the most reputable and professional education provider in our industry and in the country. Whenever I received the email that they were offering 10 hours of continuing education credit, it said pending approval in Tennessee. I've attended an Appraisal Institute conference in the past and received continuing education credit in a reasonable amount of time. My request is that those conferences and things like that be approved in a reasonable amount of time, and I think we have a reasonable expectation that provider and that type of discussion amongst the peer groups should be approved. there is not a handout. There is not an outline. They are showing slides, I think, at that time, but as an appraiser, as a professional, as a business owner, I've got to plan my entire life around getting continuing education, specifically in-person continuing education. I'm away from my family, I'm away from my business, losing the opportunity to earn money and spending a considerable amount of money to pay for the class, pay for the travel. Those are all real world issues, and they really caused me an issue this particular year whenever the Appraisal Institute conference was not approved. My license was set to expire at the end of August. The course has still not been approved up to this day. I had a period of, I think, 7 to 10 days where my license was expired. Maybe that was my fault, maybe it wasn't, but I felt like I had the reasonable expectation that that course or that conference would be approved within a reasonable amount of time so that I could renew my license on time. And I planned months in advance. It's not like I just decided last minute to go to Las Vegas to do that. In another example, we had a real estate symposium that was hosted by the Appraisal Institute earlier this month. That day, it was already approved for real estate credit. It was already approved for legal credit. It is still not approved for appraisal credit, and it's an appraisal symposium. Appraisers benefited more from that symposium than anybody else in that whole thing, but it's already approved for the other credits. Just listening to what some of the other folks are saying, it sounds like there should be a differentiation between qualifying and continuing education standard in terms of what the providers need to provide. In the legal field, I go to the Wilson County Bar Association meetings, and a judge will stand up and talk about courtroom procedure in his courtroom, and that's approved for continuing education for attorneys. Outline. There's no slides. There's no anything that's taken away from that other than discussion with your peers, and that's valuable. And I think that should be taken into consideration in discussing what should be and what should not be approved. So I've got a selfish request since my experience with this conference not being approved. My license, my cycle ended August 31st, 2022. I had to get new education in order to renew my license. I don't know if you guys have jurisdiction over this or not, but I would like for anybody that experienced the same thing that I did from August, September, October, if anybody's license expired in those cycles, to allow that conference credit to be that I could earn it in my next cycle, which starts September 1, 2022, moving forward for the next 2 years. So if that's possible, I'd like to ask for that. Thank you guys for your time. I appreciate everything you do. Thanks for your service to our profession.
Was there any comments in reply from the commission?
Is it possible for us to approve the extension of the applicability of the approval for the following cycle if it's missed out because it was pending approval?
That would all be dictated by statute and law, or by rule. So, I don't have it before me. I haven't memorized the code. I suspect that it probably would not. Will? Mm-hmm.
The appraisal subcommittee does not, the AQB does not permit carryover. It's in their rules. There's also a frequently asked question on the AQB page. That's AQB criteria. It's not state of Tennessee criteria, so carryover is not permitted.
Thank you, Will. We do have carryover in some other industries that allow for that in their statute. I think of, let's see, land surveyor being one and home inspector, but I'm glad our subject matter experts here, so that helps in that regard.
My next question is, do we have sample documents about setting the expectation for material submittal, and are they different for a seminar, a homegrown seminar where there's not a textbook but you've got a speaker and we say we have an example of what we're expecting in the outline for your submittal for approval with a check mark that there's not a textbook applicable, not a student handbook applicable, that these are acceptable documents for approval so that we are all managing expectations?
And therein lies the problem. The application does state what could be received as far as supplemental supports, but it's not required. So that comes back to the education reviewer themselves, and with in concert with the commission as some of those guidelines are sort of hammered out. And obviously that can vary because, to your point, and some of that is deliberate, because if you were to just give a hard set criteria, then that could create some of that loophole we were talking about before, because then I just meet that rubric, and then it's a rubber stamp regardless of content. So the profession is such where it requires that expertise. And so but it does, to your point, Commissioner Alexander, it does have some examples of what would be acceptable, but it doesn't require necessarily all of those things per se. That really goes back to the education review themselves. And so at this point, the commission could do something about some of the issues addressed if they were to grant that authority by expanding the education committee to include a signature and handle that like an application review. And where we get Dr. Jane's, if he was to already approve, get that other signature, that authority granted to us, it's out the door. And I've seen that really cut down some licensing time in other industries and programs as well, pretty severely. And because the board review, that is the board review, they're granting that authority to us. They're saying that's the process for which embodies our board review. And so it's been reviewed by the board at that point, because that's the process that you've put in place to do so. If you administratively grant that authority to us, and then that would go to Dr. Jane, obviously it would be the first pass, and then another signature from a commission member here. And then any questions you had, if we get a denial from Dr. Jane, then you could, upon your review, you already have it, then you could give your questions, and then we could have that conversation with me directing traffic.
I think that's a great idea.
Seems like that would address most of the issues presented today, right? If we were able to do that.
And before we Dr. Jane, did you have any comments in regards to that being spelled out or explained or introduced?
I think it's a very good idea. Like I previously mentioned, our goal is to have a very good appraisal industry and thriving industry in Tennessee, but also high quality. And I do understand, this is a more challenging profession than just the real estate broker. So I think we have to understand that the quality of the education will be a little bit higher for appraisers than what it needs to be for a broker. Aside from that, I really like the idea about making these procedural changes so that courses can be approved much faster than they currently are.
It sounds like we've got a pretty good we've had a pretty good discussion so if what we need now is to take action is a motion from somebody in that regard, that the administrative authority would be granted to the staff with two signatures from the board member, one being Dr. Jane and one accompanying.
I'll make that motion.
All right, thank you, Commissioner. Do we have a second?
Second it.
We've got a second there as well from Mr. Pratt. All in favor, please say aye.
Aye.
Any opposed? All right. Hearing none, that was approved, and then that will be our process today forward. It can be any member at that point. So yeah, we can. So that, and so we can now. You have every authority to select one of your compatriots if you want to do that, and create sort of a committee if you wanted to do that, or identify folks as part of that process. But right now, it would be an appraiser member. All right. I think we're good on that front. I think we're ready for the director's report. Much of this will be largely informational, the budget and the meeting dates. I wanted to give you an update on that. All right. Budget myself. All right. All right. So we're tracking right now. I'll for the benefit of our new members, I'll sort of give you an idea of kind of what we're looking at. This is basically a P&L chart is what you're looking at, profits and losses. You're looking at revenue, incoming, and then outgoing. So that's the scheme that accounting gave us, and so that's one we're living with. If you're looking at Edison, you're like, well, who is that? What is that? that's basically our accounts payable sort of ledger. That's also the system we all belong to as employees of the state, even though the commissioners and board members are all volunteers, and there for us to reimburse, you have to be in part of that system, and so we issue that through there, through that system. So that's Edison. But in there, we also do our other accounting from other line items from other accounts. Administrative cost backs are typically our shared expenses across the board with other programs. Obviously, we don't have our own building; we share this space, and so with that comes the lights, utilities, ink, paper, that kind of stuff. And so we share that across IT support. Oftentimes, if IT is doing something specific to us, they'll bill us direct to that, and that will show up in a line item. Otherwise, administrative cost backs is where that goes. But if they do something like they run cable for everybody, well, then we're all gonna share that. And then, well, how do you share that? How's the proportion come from? Well, that comes down to license count. That comes down to complaints, and just the proposed budget. And so, obviously, our proportion would be larger than, let's say, Court Reporters, who has 400 people, but smaller than Cosmo and Barber, who has 70,000. So and that's how they work that. So that's described that way. Then you've got legal cost backs down there. That's going to be the legal report. Meantime, our attorneys, they work on whether that be the legal report, complaints, or if they work on rules. If they're working, that's a billable hour. So that comes back to us in that regard. That's right. And then we've got investigations, field enforcement. We send somebody out, and then we're going to have to pay for that as well. If we send an expert reviewer out, you're going to see that line item there. Centralized complaints, customer service. That's our call-in center. They handle and dispatch and direct all of our traffic. And if it needs to be escalated to our subject matter expert, in this case, then they'll send that in that direction. But that's that line item. In this case, we don't need to vote on anything. If we were expending money, then we need to vote. But when it comes to just, this is just my report to you to show us kind of where we're at. Right now, we're looking at a surplus of $20,000 for the new fiscal year. Come next year, we'll touch on the reserves, and when we do our election of officers as well, and I'll give you a snapshot of that. Right now, we're just looking at the trending for the last 3 months. Let me see, I had a couple notes here too. Yeah, the large expenditures under other for August are the appraisal subcommittee national registry fees. You're going to see those pop up every probably a few months. And so when you see that, that's typical. I'm looking at the expenditures, and that's what that was. So I looked a little further down. As for technology expenses in August, we are upgrading to the cloud, and we've had some IT related support expenses there. All of our programs across the board, so I saw a slight increase in that same line item for our other programs. So at that point, that tells me that those are those shared expenses for IT. So I didn't, there was nothing there that created any heartburn for me. If there's anything that you have questions about when I first sent it or otherwise, I'm happy to, follow up with our accountant and get those answers to you. But just at the when I'm just looking at the trending, there wasn't anything there that necessarily stood out to me beyond those two items. Any questions, comments, or if you think of something later on the way home, you can always send me an email too, and I'm happy to address that. All right. Nothing out the gate. That's the budget. The meeting dates. Our last meeting, to our new members, we historically meet on Monday, and just as I guess last year, we started meeting on Tuesday. And I understand some of that because auctioneers, for example, they met yesterday, and so it can get kind of and the reasoning given to us by our former chair was travel is a little bit easier on the weekend, and I understand that, and that makes perfect sense. But other boards feel that way too, so we find ourselves sort of bunching up. But I did look at some of the dates, and I was able to get 3 dates for you, for Monday, but I couldn't do anything for you on September. So there was just no. This building is. There's a lot of board meetings happening throughout the month. It was impossible to do, but to get that for you. But that just wasn't available. So you've got 3 Mondays there. We don't have to vote unless it's contentious. I don't seem like to be a hot button issue, but if you guys just want to take a look at that, and if you have any comments as that goes. And also September, I don't know, that was a hot month, so I couldn't even get this room either. So that we're in 1A, but you guys already took care of that. Those rooms are reserved, so I try to get in there early. We've got a lot of traffic, a lot more people moving to the building as well, so we're getting a little more use out of these facilities. Also, they're going to renovate this room and 1A next to us. 1A is just right there, so if you see anything that says 1A, that's where we're headed. But they're going to renovate these rooms. I guess we're going to get a facelift. We're supposed to, I don't even know what that looks like, but that sounds good. But that's also why your meeting is a little bit later in March, because if general contracting takes a little longer, general services takes a little longer to set this room, trying to go to offsite somewhere else, Tennessee Towers, or the parking as it is right now, I just don't want to create any disruptors if we can avoid that. So we're giving ourselves some time to sidestep all of that. So when you come back in March, this should look radically different in here. Is everyone good with that, or any comments or questions in regards to that? If not, then we'll get that posted to the website. Those are the dates. You can just, if you don't mind saving the date, this is your card in that regard. So I think we're ready for the next item. Like we're ready for legal.
Okay, good morning. Hope everyone's doing well. So before we get started on the legal report, are there any ones that you want to talk about specifically first, or any questions you have?
Normally we group.
Yeah, I was going to suggest that, but I wasn't sure.
So the first 11, if I counted correctly, are all recommended for dismissal.
Yes.
And assuming that all the commissioners have looked at all of those, I can make a motion that we group the first 11 and accept council's recommendation to dismiss all 11.
And we'd have to.
Yes, you'll have to do that.
Yeah, I'll read them into the.
I didn't know if there's anyone that wants to discuss any individual one, we'll pull it out. But now would be the time to say that.
This looks like this is your consent agenda, then, is what it appears.
There you go.
I got you.
No one wants to pull anything out, then we just want to read into the record, and then we'll vote as a group on 1 through 11.
Yep. Number 1 is 2022027791. Number 2 is 2022027801. Number 3 is 2022016761. Number 4 is 2022025231. Number 5 is 2022023461. Number 6 is 2022025881. Number 7 is 2022027361. Number 8 is 202-202-4651. Number 9 is 2022-03-0081. Number 10 is 2022-03-3431. And number 11 is 2022-03-6501.
Motion, accept council's request to dismiss all of those.
Do we have a second?
Second.
Got a second from Miss Alexander, and of course our original motion.
Discuss though before we vote.
Nope. Yes, sir.
We have new commissioners, and they may not be up to date on the first 3 are submissions by Fannie Mae, and I think probably Commissioner Bennett can explain. In our last meeting, we just agreed that anytime Fannie Mae makes a referral, we're going to dismiss it. But Commissioner Bennett, I think, can best explain why we made that decision.
Fannie Mae has been sending in letters on any reports that they determine they feel like are deficient. As the market is rapidly changing all over the country, I am getting now at least one of these a week to look at for our appraisers in the different states that we deal in. It doesn't necessarily have any basis in fact. It is based on an algorithm that no one can quite identify what the logic is behind it. So we decided, unless Fannie Mae specifically files a complaint with the board, we're not going to discipline an appraiser based on And if it warrants disciplinary action, we feel like that the homeowner or the lender or potentially the AMC could file a complaint if it warranted that.
To add to that, it's not just a letter; it's an automated letter. So there's really nothing pointed out. There's no signature. It's just an automated thing that gets sent out from Fannie Mae, and that was also a basis for our decision.
And just to make a general comment about it, one of them did go out for a review, and there were violations found, but it was referring to the Fannie Mae vote. So just wanted to make you guys aware that sometimes there are being violations found within these Fannie Mae complaints by an expert reviewer. If that changes any opinions.
But none of these.
One of them.
One of them?
Yes, but
you requested dismissal.
Well, because you guys had voted last time to not have any of these move forward. Any Fannie Mae, to be specific, not these. Any Fannie Mae complaints to move forward.
And that doesn't mean that that report won't come up at a later date.
You also would have to file a complaint against it, but
yeah. And if the report was that bad, someone will file a complaint, I'm sure.
How many of these would you say you're getting?
Quite a few, I would say.
I don't see as many emails about them as much. Like, that was the only concern about, carte blanche dismissing them, is that sometimes there are violations, but that's, neither here nor there, since we decided to close them at this point. But that is something just to note that, but as Commissioner Bennett said, if there is an issue, possibly that would come up in the future. I just don't circumstance in the future if we would actually see. Does Fannie Mae send signed letters to states, or is that just something you had us request that doesn't happen?
That I think, and obviously there's a lot of thoughts. We had that discussion of, if you're just curious, you could see that tape. It's posted up there. We were talking about the computer automated ones, and it's kind of like we do audits in some other programs. If you cast the net, will you find somebody that didn't do the seat? Certainly you will, but do you not do the audit? Because you have to weigh that with the administrative burden as well, and with the sort of thrust. If you're getting one or two, maybe then the needle moves in one direction. If you're getting 10 or 15, which in some cases we were getting some of quite a few, and then you have to weigh that into consideration as well. If you're wanting an idea about how many we had, you could go back to other legal reports, and those will be identified, and then just count those up, and that'll be your number. And you won't see those now because that was the commission's majority decision. There was some dissent, as regards to that. And some good discussion, which is great. That's why we're here, is to deal with those difficult issues, those complex, nuanced issues. And so, and it was decided then not to open those computer-generated letters that were being sent to us in that regard. And so, so you won't see any after this report. This is the holdovers. These are the ones that were already open.
Right. Yeah. So you won't see that. You won't see any moving forward on the legal report. This will be the end.
And I will say, we still, on the compliance reviews that we do before we send the appraisals out, because we're required to use a USPAP review, we still have 75-80% we send it back to the appraiser on first submission for corrections. So, there's a lot of reports that have something that needs to be fixed on it. Unfortunately, a lot of times, and I know this is going on the record, but if an appraiser, and I understand for speed and convenience, but the cloning of reports and then consistently putting a bad clone out there, and then you have to go back to that appraiser almost every single time to have them update the same thing, is a bad practice. And I wish they would not do that.
Oh, and to keep in mind too, Fannie Mae, and they weren't giving us their criteria or their algorithm for why they're generating this either, known only to them.
It's just the SSR score.
And it was also, to point out, it was not just submitted to the state, it was also submitted to the appraisal management company, the lender, whoever. So our thought was if there was an issue, these people would do a review of it and file a complaint if needed.
So you're saying there's no specific complaint that the appraiser can answer? It's just a general, there's a problem here, but we're not telling you what the problem is. Is that what you're saying?
Most of the time when we see them, there's a heightened risk of overvaluation. The comparables used are different than model comparables available. I have one specifically not in this state. Then an appraiser jumped the interstate to use his comparables, and I've taken your classes, so I know that's generally a no-no. But on the other side of the interstate where the subject was, it was a subdivision, then farmland. There were no sales in the subdivision within 6 months. This is in a state that had probably the highest appreciation rate in the country. So he went to the other side of the interstate, explained why he did it. 5 months later, they came back after the loan had closed and said that comparable used weren't appropriate. They wanted him to use comparables that were 11 months old in the neighborhood. So what we did is we sat down and I had him add those comparables to the report and put a time adjustment on there. And lo and behold, the value was the same. At the same time, we were telling these appraisers, use comparables within the last 3 months because the market is rapidly changing. So we're telling them to do one thing, and then we're coming back and saying, do something else. And I think right now, for the current market, appraisers have to be extremely careful about the comparables they're using, the date in which those comparables sold, and or the date those comparables went under contract. We're seeing a lot of houses that went under contract a year ago that are selling for a much, much higher value than a house that just went under contract, even though they were built about the same time.
Legal report. All right.
Can we call the question?
Yeah, that's good. That was a good pause. That was needed to sort of get our new members caught up. Thank you for that discussion. Can't remember if we voted on that one.
No,
we haven't voted on any yet.
All right, so we do have a motion. We have a second. All in favor for accepting the council's recommendation on the first 11 to dismiss, please say aye.
Aye.
Any opposed? All right, hearing none, I think we're ready for the next set.
Okay, we'll go ahead and move on to 12 now, and I'll read the docket number into the record. It's 2022026781. This was an administratively open complaint because respondent failed to complete Tennessee's AMC National Registry. They were sent notice. Based on their failure to complete the registration, I was recommending issuing a letter of caution, giving them 30 days to complete their registry, and if they do not complete it within 30 days, authorize issuing a consent order for a $250 civil penalty.
Motion to accept.
Second.
All in favor?
Aye.
Any opposed? All right, hearing none. 13.
Okay, 13 is 2022031161. Complainant is the seller of the home appraised in this complaint. They allege that respondent made numerous mistakes and violations in their appraisal of their home. Specifically, they state respondent made incorrect adjustments, used improper comparables, and did not take the time to properly conduct the appraisal. An expert review was conducted. The expert found the following in each of sections. In the neighborhood section, they found that the boundary description set out a very large area. For example, they said 1 unit housing price range is stated to be from $30,000 to $2 million, with the predominant value of $260,000. In the building and improvement description section, they found that the roof on the home is actually metal, however, is reported as shingle in the original appraisal. Under replacements, they found that the appraisal had a statement that no improvements in the last 15 years had been made. However, the owner cited that a new metal roof was put in 2 years prior, as well as a new HVAC system 8 years prior. For the bathroom count, the appraisal stated that there were 2 bathrooms, while the owner states the home had 2.5 baths. Just kind of under a little other section, they noted that the general description section for the design states ranch as opposed to basement ranch, and that the house has a walk-in basement which reportedly houses water storage tanks for the subdivision for which the owner reportedly receives a use fee. They note that the appraisal noted the tank storage but reports the structure to have crawl space as opposed to the basement. Under the cost approach section, they note that cost approach was applied, although it appears to be limited and confusing. They state the cost approach conclusion was $564,357, which is $62,000 below the final value conclusion. Within the development of the cost approach, they note that the allowance for the land value is not supported. Under the sales comparison approach section, under adjustments, they note that an across-the-board negative adjustment of $30,000 is confusing to the reader as the grid associates adjustment with the community water tank storage in the basement. They note that the reader is unable to find support for the adjustment. They note that primary issues in the appraisal relate to errors and that the extensive number of errors leave the report non-credible. Based on the expert reviewer's finding and the respondent's history, I was recommending that the commission discuss continuing education to be required within a consent order within 180 days of the execution, and for the classes to be completed in addition to the continuing education minimum requirements.
I've got a comment.
Okay.
Some of the issues are I don't know, ticky-tacky, but there are some that do have merit within the cost approach section. Not supporting the land value, that's a sales comparison approach, and within the cost approach, and is not completed. And then it looks like there are some errors within the sales comparison approach. So if we were to issue continuing education, I think a sales comparison class at a minimum would be necessary.
Do you have an hour requirements that you would suggest?
I think it's a 30-hour class, is it not?
There's multiple options that you could do on our website. I don't know if that's up to date, but whatever you guys, if you want to do 30 hours, I have no problem with that, but I just didn't know if you I just want to clarify.
I'll let the other commissioners provide some discussion
Okay.
and then make a motion.
Can we go back to the history? There was a 2013 consent order for alleged bias. Can you explain?
I don't have the consent order back that far. It's not in our records. It's too far away. So all I have is that information, what's in our system, but
We don't know what the consent order required.
We do not.
And that's like a very, very generalized statement. So I don't know what that means. So I would just take it as a 2013 consent order. I don't know who wrote that summary. Yes.
It was just more of them having history and then violations being found again. But you can totally take that how you want to move forward.
I have a use question on the water tanks in the basement. What use would that be considered for this property? Certified residential appraiser even be doing appraisal on this property?
We don't even know. Oh, it says water tanks, though. Okay.
For the subdivision?
It says here.
And he gets paid for it. Hey.
The complainant indicated that the appraiser did not spend much time on the property. And I usually take that with a grain of salt, except he got the roof wrong, he got the bath count wrong, he totally missed the basement. I don't even wonder if he went to the property. I guess he did because the complainant indicated that he was there but didn't stay very long. So that's an issue that I don't know, might be addressed with a dollar amount, a fine. And the only reason I would bring that up is there's a previous consent order that we don't know anything about. If this was a first offense, that'd be different, but this is not a first offense for this. No, I'm just throwing something out to see if anybody.
I would be in
wondering-
favor of some type of report writing or something to kind of capture some of the ticky-tacky items, but kind of description of the improvements, going through report reconciliation issues.
Okay, so I have some additional information about the consent order. So it looks like it was a $500 civil penalty and 15 hours of education, a residential report writing course. And it states that this complaint was filed by a home retailer and included alleged bias / prejudice in the appraisal of manufactured housing and use of inappropriate comparable sales, omission of subject property amenities, and undervaluing a residential manufactured house. That's the very general information I have.
Well, after that information, they've already taken report writing and didn't seem to make much of an effort, so I would be in favor of a civil penalty.
Yeah, they took that in 2012.
I did notice, though, that the complainant stated that they made incorrect adjustments, used improper comparables, and did not take the time. Well, we're seeing what they did in the inspection, but for instance, my first thought on this basement, was it really a basement or was it a crawl space? And we don't know that from what the information is here. We don't see any information about the comparables. You know, if the reviewer thought they were good or if they were bad. So
Let me pull up the review and see if there's anything specific in that. Typically, I just include what they find as violation. So if it didn't include as a violation, then they must not have found the comparables in a violation. Pull up the review. He said
Ticky. Well, I'm just saying the report from 2012, that the reviewer for that previous report said that it was complete and credible without bias, but there were careless or negligent errors in that report.
Yeah, NewsPap says that as on a whole that is an issue. So
Right. No, I'm just saying the 20 that we're talking.
And it would have been good to know how big these water tanks are. That's going to give us good indication if it's a basement or a crawl space.
The reviewer did note numerous times that he's finding that the amount of small errors are adding up to make it not a non-credible report.
I think Commissioner Bennett has a point that with these water tanks, I mean, you get into competency licensing issue. He made an adjustment, or he or she made an adjustment for these in the sales comparison approach of just $30,000 with these community water tanks that they're receiving a fee on, and so that's slightly concerning to me. And so I'll go ahead and make a motion. I'll make a motion that we recommend a 30-hour sales comparison approach class in addition to continuing education, along with the $500 civil penalty for this issue.
So we have a motion on the floor. Do we have a second in that regards?
I'll second it.
All right. Any discussion? All right. All in favor, please say aye. Aye.
Just sorry, really quickly. And do you want it to be the 180 days to complete it? Just to note that in the
Correct.
motion. Okay.
Any opposed? All right. Hearing none. That's as it stands. Did you have anything else for the legal report?
That's the final one on there.
Did you guys have anything else you wanted to touch on? Okay. That's it for legal, so that we were able to move on to new business. Is there any new business, anything that the board would like to discuss or introduce for discussion? Yes, ma'am.
On the board, do we not go back to the minutes from the last meeting and look at the legal questions on those, the items that were said that they would be brought forth at this meeting?
Those are represents, and those will be, I was going to say represented, but that's redundant. That'll be on your legal report and noted at the very end as represents. And if they're not, then typically it's because we're either lacking new information or we're waiting on some outstanding information. And then, of course, the Miss Taylor Hilton can explain that as well.
Yeah. So last time there was votes to have 2 re-reviewed. Unfortunately, the reviewers we only have a limited amount of reviewers currently, and they're just backed up, and they haven't got to re-review them yet. And so they will, I would assume, without a doubt, they'll be done before the next one. So then at that time, they'll be represented.
A good catch. Oh.
I have a question as well. So hopping back into the education and how, just logistically, can you explain how this will work with the commission member?
It'll be a SharePoint. We'll give you access to a SharePoint folder to keep it secure and encrypted. And then Jane has that access right now already. We will extend that out to additional reviewers, and then you'll see that the day we get it. I mean, when we process that application, we do so very timely. Within probably, it's rare that it extends beyond 2 days without some contact from this commission as to regards to the deficiencies that are quickly identified. If they're missing something just basic, we take care of that. If there's some rubric from the education committee, or in this case, Dr. Jane, then we express that as well. We reach out to him, but we'll drop that in the folder and then let them know. So it'll be basically just whenever you look at your folder. And obviously, if we're going to keep you attuned to that, so you don't have something just sort of languishing in your folder, much like we would do any of the experience reviews. We could go that route, but typically SharePoint is how that would happen.
Okay, and so Dr. Jane will be the first point to look at it, and then it would be available to the rest of us. Yeah,
what I would do in that regard, so we don't waste time, is I would probably send it to both, because I mean, typically, you can look at those, and based on whatever rubric you're applying, and process that pretty quickly. And that's also good too, because if we have one approval and the denial, typically what we do is we ask them in our denial to explain why they denied it. So that way we can have that discussion, because someone's denial may be somebody else's approval.
What about if it's a conference and he's requesting more information? How would we communicate with him about that? Or what if he wanted to reach out to an appraiser member and request some more information?
Dr. Jane? Mm-hmm. He would just send that directly through me, and then I would reach out. I'll just relay the message, as well. That way we don't get into sort of, discussion or violate any sunshine laws or anything like that. So,
because it sounded like a lot of the issues stem from CE and seminars, and so that's where I think the issue with getting the required information is. So he will look at these first. If he thinks that more information is required, then you would let us know, and we could provide some clarity on the conference.
Yes, sir. And then that could be further discussion. That way we can continue until we get to a place where we get sort of a consensus on that.
further discussion, just so we're clear, in the email.
Yeah,
Okay.
that will happen in email. But if it looks like something broader to the board, like if we're hitting a bottleneck, like we're still not getting stuff approved that others may feel like should be approved, and then we'll elevate that, we'll escalate that to the discussion for the board as well. At the point that we, just much like we did today, we would just introduce it to education report at that section and have that discussion again. And some of that, we're going to run into that. We do that with applications. I mean, obviously, we approve a lot of applications when they meet the criteria, but you had 2 today that were just, are a little ticky-tacky, as Mr. Atwood would say. So we're going to look at those. There might be some discretion that could be applied. So we're going to bring those to that. It would be the same thing here. We run into some courses like that.
Perfect. Thank you.
Are there questions from the commission? All right. Hearing none, I think we have we could have a motion for adjournment if we could so entertain that. Do we have a motion to adjourn?
So moved.
All right. Do we have a second? We got a second from Ms. Tuck. All in favor, please say aye.
Aye.
Any opposed? All right. We are adjourned. Thank you.
All right, welcome.